Hello everybody. Thank you all for joining today. It's great to see a full house and some familiar faces and some new faces too. So my name is Eline Chivo. For those who don't know the Center for Data Innovation, we're a think tank based in DC and Brussels, and I cover here digital policies at EU level. And this year, one of the biggest topics discussed is the so-called forthcoming Digital Services Act. So we've seen that on various occasions, EU policymakers have updated a number of policies that touch upon the intermediary liability framework of online content. And lessons learned tell us that overly prescriptive rules and one-size-fits-all solutions could have unintended consequences that restrict innovation or set obligations on online platforms that may not be appropriate for the full diversity of internet participants. Now, the next Commission's policy agenda includes the Digital Services Act, which will set out new liability and safety rules for online platforms, for services and products alike, and this will lead to the reopening of the eCommerce Directive or to the creation of a new instrument. Now, the eCommerce Directive, which Pravat recalled yesterday, is sometimes called the Constitution of the Internet, sets out a set of standard rules for liability of online intermediaries, and these rules provide important protections for online services to ensure that they're not unfairly targeted for the content of their users. And any updates to these rules should modernize definitions, certainly, but also ensure to maintain a proper balance of roles and responsibilities of online intermediaries to protect consumers and avoid unnecessary penalties on digital platforms and other stakeholders. Today, I'm very lucky and honored to have four great panelists. Thank you so much for joining. So we have Pravat Agarwal, Deputy Head of Unit Online Platforms and E-Commerce at DigiConnect European Commission. Bruno Bazarisco, Managing Economist at Copenhagen Economics. Benedict Blomeyer, Manager EU Affairs at Allied for Startups. And Anja Helsa, Public Policy Manager EU Affairs at Facebook. Thank you very much all. I will kick off the discussion with a few questions for our speakers, and then I see you probably all came with burning questions, and I want to make sure you have a little bit more time than usual for questions and answers to interact as much as possible with our panelists here. But my first question is for you, Pravat. So when announcing the agenda for the EU, President-elect von der Leyen said that we'll have a DSA to upgrade our liability and safety rules and complete our digital single market. Naming the act does indicate that the preparations are on the way. We know that. Some work has been done. What can you tell us about where the Commission stands in the process? What should be, or what is the ambition of this Digital Services Act? And perhaps is there anything worth recalling or reminding us, or do you know anything that we don't know yet?
Okay, is this working? Should be on, right? No? Yeah, okay. Well, so thanks, Aline, to giving me the floor and the kind of tough questions. I think one of the challenges will be for me is that we're planning on making a proposal end 2020, so it's more than a year to go. And one of my challenges is not going to bore you with the same pitch, for a year, So I'm already running out of examples, so I'll try and change a little bit and every time say something slightly unexpected, so just to keep you awake, in what I'm saying. So, as you said correctly, President-elect von der Leyen announced that we would have a new Digital Services Act to review our safety and liability rules. Services are working, my team, together with other colleagues, we're working on the assumption that this is a revision of the e-commerce directive. Of course, the college is not yet in place. It's coming. It's hopefully going to start working on the 1st of December. But there have been various statements. I'm sure you've all heard them by Thierry Breton during the hearings, and also by Margarete Vestager in her hearing. That gives some kind of contour and that gives some kind of direction of travel. And we're using, of course, this direction of travel for the preparatory work. So at the moment, what my team is busy with is kind of looking back a little bit at the e-commerce directive. Looking what were the original objectives. I already said it yesterday in Parliament. I'm sure many of you heard me say it also in other events. Asking ourselves what did the e-commerce directive try and achieve? Are those objectives still valid today? Was it effective and efficient in achieving those objectives? And are there new challenges today that we should consider? And that's the kind of preparatory work that's going on. And I'm happy to kind of go into more details. I think I said yesterday, roughly speaking, the 3 original objectives of the e-commerce directive was to create a single market. I keep insisting on this. This is something that keeps getting lost, because at the moment there's also a lot of discussion in the US around the reform or potential reform of Section 230, which is kind of analogous. It's not exactly the same, so and it doesn't have the kind of single market dimension that the e-commerce directive has. So and a lot of commentators who are making kind of analogies between the American system and the EU system, there's a lot of nuance that gets lost, and also the kind of intervention logic, if you like, is not exactly the same of the 2 instruments. Although of course there are many analogies and there are many similarities, but it's important to stress that one of the main objectives, if not the first and the foremost objective of the e-commerce directive, was to create a single market for services, to prohibit member states to restrict information society services. In those days, information society was kind of the buzzword, and today we speak more about digital, so it sounds a bit more modern than information society services. So that's something that we recall is a kind of a rule that fixes also freedom of establishment, treaty freedom to provide services across borders. Those are all kind of put into secondary legislation in the e-commerce directive. It's a really important thing. No prior authorization. So if you want to establish a digital service, even ones that kind of have a communication value, no member state is allowed to ask you for a license to establish. Those are really important parts of the e-commerce directive that kind of get lost in the discussion around liability and so on. So that's one of the main ones. The second one is around providing a legal framework that effectively fights and incentivizes the fight against illegal content online, while protecting freedom of expression. So those are the kind of core objectives that the original e-commerce directive had. And by and large, we think, those are really still valid objectives today. This is something that we still want to maintain. We see the single market being refragmented, in areas such as hate speech, for example, the German hate speech law. French have notified a measure under the internal market TRIS system, transparency directive. Many of you will know it. I have to say a bit more about this. We see, and we see, of course, that some of these rules make a lot of sense, and we also want to have better rules in place to fight against illegal hate speech online. This has been something we've been doing through the code of conduct. Of course, Facebook is participating in that very actively. But we also understand that some countries want to do more, but that shouldn't necessarily lead to kind of a patchwork of different rules in the EU. This is from our perspective. Maybe typical kind of Brussels way of looking at things. Is a little bit worrying. I think that creates new barriers in the single market that limit our ability to have companies grow at home and to emerge at players. It actually, I think, for large companies such as Facebook or Google, I think it's not a big deal. There's enough money in the bank to have legal teams in every country. But that's not really how we see the single market developing. We really think that it should be simple, uniform, harmonized rules as much as possible without actually kind of taking the nuances away. Of course, a lot of, for example, in the specific case of hate speech, or defamation, because there were court cases recently, and there's a lot of local knowledge that's necessary, language, local rules are different, so that's not something necessarily we want to harmonize, but we see a kind of need to make sure that a streamlining of certain aspects, that's something that is new. So that's something that is kind of informing. That's kind of the way that's the place we're coming from. I'm happy to kind of take more questions on the details. When you just ask me, is there something you know that we don't know? I mean, that's a really funny question. So of course, I'm sometimes I get surprised myself what other people know that I don't know. And so when I come to meetings, when my current head of unit Werner moved to the Vestager cabinet, I heard about it in an event in London, and from some other stakeholders, and say so. What are you going to do? So sometimes I think you overestimate how much knowledge we have. Even though he's just the office next to mine. So it's just to say that. But maybe one thing that perhaps is I just want to kind of put on the radar screen of this audience perhaps is just that some of you will know, and I see we've also negotiated the platform to business regulation in the last mandate. It was adopted in spring, and that was something looking at fairness in the platform economy. So that was not really related to the service provision across borders like the eCommerce Directive or illegal content. There was much more about kind of bargaining asymmetries and so on. And we've always said that platform to business instrument was a kind of a first of 2 steps, and then we would take a bit of time to look further whether additional issues are emerging, and just I want to say that work has not been forgotten. That's ongoing. There's nothing really to report at this particular time. We're working with an observatory of experts and commissioning some studies, but just to know that, of course, the Digital Services Act is taking a lot of the oxygen of our discussions at the moment. But we are still also working on other related areas, without any kind of big announcements that I can make today, but this is still work in progress, and we're examining some of the issues that kind of were on the table during the negotiations of the platform to business discussion, including how to facilitate greater data access and so on and so forth. That work is still in progress, I would say. So I'll stop there.
Thank you very much for that. I think we'll have the opportunity to get back to some of the points you've mentioned. Before that, I'd like to turn to Anya from Facebook, and perhaps Benedict, you can jump in right after. My question is actually twofold. What are the problems that you see that updating the rules should address? And what are really the bones of contention? What are the problems? What are your concerns? Why are you concerned? For instance, I heard 2 things. I heard Commissioner Breton say in his hearing that the liability clause will not be impacted. But at the same time, we heard from Werner Stang that the discussions about the DSA will definitely be messy. So I'm just wondering, what is your perspective from a Facebook perspective, and I like the startups perspective on those issues, and perhaps what should not be in the DSA? If you could tell policymakers something about that. Thank you.
Sorry, I can start again. Is this working? No, mine is switched off. Is this working now?
Yes.
Yeah, sorry. From our perspective, perhaps before I get into that, I just maybe very briefly walk this audience through how we approach it today in the existing ecosystem, basically governed by also eCommerce Directive, but also other sectoral legislation that exists and originate also from the European Commission. First of all, Facebook community is governed by a set of community standards which are global and comprehensive, and one of the key principles there is principle of safety of our users. That principle, of course, can be further lasered down to, for example, issues like there's no space for violence, there's no space for hate speech, there's no space for any type of abuse on Facebook. We just don't want to have that. In order to achieve such a ideal environment, and of course this is never a journey finished, right? You can never have nothing out there because there's always some actors who will try to circumvent your policies, but also your tools. And here maybe the tools are quite important because we of course want to be quite proactive on certain types of content, especially those the most egregious types of content like CI or terrorist content, which any moment of it being live is of course huge risk to our users and huge risk to our community. So we basically try to distinguish internally between the content that violates our community standards and also content that is for legal notice. And the way we approach it is that, of course, there's content that is always illegal, there is never a question, and it goes for takedown even before sometimes it's uploaded. And this is, as I said, CI or terrorist type of content. We, of course, work very closely with law enforcement and number of other partners to better understand how we can be quite proactive about it, how we can do it efficiently, how we can basically prevent such content from appearing, and how we can also help law enforcement with catching such actors, because of course this is criminal activity that not only has to be taken down, but certain follow-up steps needs to be taken in that context. We also have to deal with situations when the content sometimes is illegal in some jurisdiction, yet is not illegal in some others, and this is quite common right now in Europe actually, where we have a single market, but when it comes to content policies, it's very diverse, and we need to factor that in. We often geo-block in that situations. We also work very closely with law enforcement again and NGOs network to really better understand and really deep dive into, for example, policies around hate speech, policies around what drives certain contextual situation in certain either member states, either regions, because we of course don't have all the knowledge on this, so partnership here are very important. And thirdly, the content where our users have to basically notify us because they will be asserting their personal rights. This is content that relates to IP infringements, for example. We need to be informed. We can be informed about it through various also proactive tools, like for example in the copyright space we have a program called Rights Manager. However, this needs to be an information somehow given to us. We will not know otherwise that certain personal right was infringed. This also goes for defamation issues, which perhaps is quite interesting how the recent judgment will affect. The recent judgment I refer to as the Green Party versus Facebook case was just released, the judgment from the Court of Justice, how that will affect those discussions we're having today, because this is quite profound kind of shift from the what we would understand a usual direction. And finally, we also have a notification channel for infringement of the community standards. There's a lot of overlaps between the two, but yes, there are certain things that we just don't want to see on our platform, because that was the idea behind putting those rules in place. And there was quite a lot of discussions about it, but we just feel like this kind of set of standards is important for us to have it, because our platform is global. So in this context, I mean, what can I say about problems? I mean, problems are of course quite well already discussed, I think. I think if you want to be a responsible platform, and we definitely strive to be one, and we cannot really afford even not be one with so many users trusting our service, it's very important that this kind of proactive measures, proactive steps are not actually hindered through legislation, and on the opposite, they're encouraged. And I think that will be the key issue we will be looking when we are going to discuss DSA with the European Commission and other partners. DSA, by the way, to me, from my very limited knowledge about it, is also lots of different things there, but of course here today I understand we discussed the potential review of the eCommerce Directive, and in this context I would really pledge that basically we take into account this fact that platforms do want to be responsible, platforms do want to be do want to implement various measures that oftentimes put them outside actually of the eCommerce directive regime, and it's quite difficult later to kind of balance those things and make sure that on one hand we fall into certain category of platform, yet we do have certain measures in place as any responsible player on the market. Liability clause, I can imagine, will be discussed. I don't know, Prabhat will maybe know more, I'm sure. But I think any kind of discussion, and I hope Prabhat would agree, and the European Commission more broadly, has to keep certain principles in place. Platforms like Facebook, but many other players here, are in a way, well, not in a way, they're hosts of the content. They're not an editor, they do not publish this content, they do not alter the content. So if we don't keep certain principles around that in place, it will be very hard to, you know, keep functioning of platforms like ours, where people come and with, of course, recognition of certain rules that we have through community standards, but also principles of the law, will be able to come, share, discuss, engage with other users.
Thank you very much. And yes, indeed, you referred to the fact that for platforms it's important to be able to navigate the environment with more clarity, so as, you know, as far as their roles and responsibilities are concerned, and the fragmentation of that landscape really can be an issue in this respect. Benedict, this landscape definitely is different from 20 years ago. I've read somewhere that in the last 3 years the number of startups has tripled in Europe. So maybe we can have your perspective on what that means for this.
Thank you very much. It's on, right? Yeah. So Eline asked us not to prepare opening remarks, which I fully agree with. But you won't get away without me thanking you on behalf of all of us, I think, for putting this together. Eline is a one-man show here, and I think it's amazing that we have a constructive debate here today. So thanks a lot. One sentence or two about Allied for Startups. We're a global network of startup associations. Our mission is to make sure policymakers and governments know about startups when they're making policies that affect them. So, when we approach the Digital Service Act, we're trying to think of the prototypical European entrepreneur who has European values in their DNA, who's going the extra mile for their users, who's focused and user-centric, and who is navigating a fragmented market. And for the sake of this argument, let's call him Thierry. And we really think that Thierry should be the winner in the Digital Services Act. And there are some things we can maybe do to make Thierry's life easier. So for instance, if he is taking proactive measures to moderate content, we're talking about the Good Samaritan clause, we think that this should not increase any potential intermediary liability responsibilities. We do think we could clarify some of the elements, including, I mean, we've talked a lot about active-passive, whether this is still relevant in this shape and form, and also reducing fragmentation, as Prabhat alluded to earlier. Where we're coming at this issue from is we've had a member consultation over the summer, been busy. We've published already 6 principles with which we'd like to accompany this debate, and I'm sure we'll get to more of them in a moment. But yeah, we're really thinking about how we can make sure the small European entrepreneur is a winner at the end of the story. And if you're asking what some of the bones of contention could potentially be, I think in this process it's going to be very important that we stay focused on, you know, a few things or a few unclarities, or maybe if there is a market failure, and this is proven to be the case after studies by the Commission, that this can be potentially corrected, and that we don't make this a so-called Christmas tree wish list. I know it's close, but the more issues we add in here to be solved, the harder it will be, for instance, for startups to have a clear voice in this debate. Then I think Anja already mentioned it, and I think you're probably more aware of this issue than we are experts on it, but there are, of course, many different definitions of what constitutes illegal, harmful, controversial hate speech. And I think this will probably be an issue in this debate. And thirdly, I'd mention that, of course, we are in a unique political climate. There's a techlash discussion, and of course, around Brussels these days, there's a lot of discussion about digital sovereignty. And you know, we would hope that we can still, despite this discussion, have a fact-based discussion about how to empower Thierry, and not just think about the big foreign tech giants.
Thank you very much, Benedict, for your contribution. Now, I'd like to ask you, Bruno, you're an economist, and from your perspective, from that particular perspective, maybe you can share with us today what do you think is the role of intermediary liability rules for the single market and, you know, the so-called level playing field. And maybe you have some reactions for the other panels.
Eileen, thank you first of all for the invitation. Pleasure to be here. For those of you who may not know, Copenhagen Economics is a specialized firm. Back in the day, a spin out of the Danish Ministry of Economic Affairs. Now a private firm with about 100 people in Brussels, Copenhagen, Helsinki, and Stockholm, working in competition, regulation, international trade, and public finance. A diversified business across communication industries, network industries, ministries, European institutions, Parliament, and so having served 8 different Commission DGs. The question of online intermediaries' contribution and the role in the single market was fundamental. We've researched this already back in the day in 2010 in work for the European Policy Center, thinking about what is the productivity impact of the digital single market. What is there in the single market project that, when translated at the digital level, gives benefits across the European economy, across the various theories, and that are driving a variety of transactions, we would call them in economics. Now, what do we mean by that? The intermediation business model, which today we call platform, already existed, of course, in the offline brick and mortar economy. Digital tools, technologies have brought down barriers to trade internationally, but also within neighborhoods, within countries. So already back in that earlier part of our decade, we found that via online intermediary business models, there was a contribution to the European economy, a parallel twin contribution, a direct contribution to GDP, together with a contribution to productivity, which together were at a level of 430 billion euros per year. Practically similar amounts in direct GDP and productivity impact. What does this mean? This is because ultimately an intermediary business model thrives because of the symbiosis, thrives because of the ecosystem of information, services, goods, and content that are distributed following essentially the matching of more demand with more supply. And this is essentially aligned with the intuition of what a single market is for, is to be able to connect more consumers with more firms, and firms within themselves, and consumers with consumers, so all the various combinations of B2C, B2B, C2C. So this has been an important driver of single market development, and at the same time, with tech and digital tools bringing down frictions that are in the overall economy, other barriers becomes more exposed. So if there are different regulatory treatments between countries, if there are different interpretations of the law or other frictions in transport costs, that will become clearer with the as we move to more and more digital use of digital tools in business and consumer use. So for us, an important question is to think about whether the rules that we see overall in the economy, so let's say the rules that apply offline, if they're fair enough offline, are they also fair enough online? Are there any factors in online transactions, in the online exchange and distribution of goods, services, information, content, that makes a different balance justified compared to offline? And we do know that there are some favorable features of online tech tools, because there are essentially several features of having the possibility to see more transparently, to be able to access evidence in a persistent way, which is loggable, is scrapable. We can see more. We can all see what is happening online compared to what is happening in various brick and mortar environments and ecosystems. So that means that there is that more and more players have a stake and can contribute to healthy online ecosystems. I'll probably stop here for now, and I look forward to the next questions and interactions.
Thank you, Bruno. You referred to tech tools. We're talking about potentially automated filters. So what we heard is that the prohibition of the general monitoring of Article 15 would be maintained, I believe. However, my question would be to Rabat, will the DSA, you think, consider including the use of algorithms for automated filtering technologies to ensure transparency and accountability? And I'm asking this because if we make the use of technology more or less mandatory, or we sort of imply we need to use that, maybe not all platforms would be able to use that technology to the same level, and we also know that technology isn't necessarily perfect yet. Do you have a reaction to that?
Yeah, thanks. Great questions. I mean, I just kind of take a slightly higher level response, before I kind of zoom in to what you have, because in the first round I spoke a little bit about kind of the single market dimensions, and that was a big thing. Now we're zooming in a little bit more on the liability regime, and of course, just to recall that Thierry Breton, the other Thierry, has said that the principles would be maintained of the and that including the prohibition of general monitoring in the reform of the eCommerce Directive. So, but before we go on to that level of detail, because of course a lot of people who are experts in intermediary liability, we kind of sometimes are in a little bit of a bubble and ask the kind of questions that you are asking right now, which is let's zoom out a little bit and then just share one piece of experience. When I, for many years, I have had the task of explaining to newcomers, politicians or very senior managers or what the liability exemptions are in the first place, and I think since I have started working on this topic, I don't recall a single time where somebody didn't have a kind of instinctive reaction, say, why should there be a safe harbor in the first place? So just to why, particularly I think this is a kind of sentiment that was particularly strong and amplified also in the techlash kind of things. Why should there be a safe harbor? Why should there be exempt from liability? We should go the other way. This is like the wrong direction. There's also a huge amount of confusion around the word of Good Samaritan. I think we heard it again yesterday. I kind of try my best not to use that expression, because I don't think it actually captures very well. I think what both Benedict and Anja said capture much better is that we want to make sure that there's no legal barrier that stops a company from doing the right thing. So that's just a kind of a zoom out a little bit. Same thing about the kind of prohibition for general monitoring. I think if you read the text of the prohibition, which is relatively unique, I think, in the world, Article 15, and that doesn't have an equivalent in the US system and so on. So it's not immediately obvious what the primary objective of that article was. And I think just it's important, and Anja already mentioned that this was subject to a recent court ruling, which is very controversial and so on. Our view at the Commission is that both the prohibition to monitor had two functions. First was to actually ensure that the liability exemption, as it stood, functions in the first place. Because if you say that you are only held liable once you have knowledge and control, but at the same time you have an obligation to check, then it doesn't work, because then you automatically acquire kind of knowledge and control. So it was kind of the second leg of the liability exemption, in the European Union. Then that's a very legalistic and kind of maybe technical thing for those who don't understand, but the kind of underlying rationale has two elements to it. One, again, is economic. Is that if you are a type of business, whether you're big or small, makes no difference. That intermediates a lot of third-party content, be it goods or information or services. It's economically not viable for you to check every piece that you're intermediating, and the scale of, you can be the biggest company in the world, or the smallest, the amount of information that you can intermediate in the information society today is so enormous that even with 20,000 moderators like Facebook has recently hired, it's going to be a tiny fraction of the amount of volume of comments that go through your system. Like about billions of hours of YouTube videos, but leaving those aside, if you want to have any kind of business model with third-party content information, that's not going to work. Second thing, so there's an economic rationale, is that these business models won't function. So this is something that if we want those business models, then we have to put a legal regime in place that allows these things to function. Second thing, though, is that, and this is an important distinction, is that there is actually also a fundamental rights link. This is why the Facebook ruling against the Green Party politician was so controversial. Over years, people have said that monitoring is kind of basically a form of surveillance, it's a form of control, and it's linked to all sorts of things. So even and that was already there in the legislative history when the e-commerce directive was there. So this brings me to the other high-level point. I'm sorry, I'm not answering your question, but this is an important point I just want to make. Is that the other high-level point is that maybe also to Bruno and the economic analysis, is that I think that we cannot clearly distinguish the economic rationale of the e-commerce directive from its societal function. So and that's the reason is that we are intermediating goods online, but also speech, and also a lot of informations that are important for the functioning of society. So it's neither a purely economic efficiency argument. So of course, matchmaking between goods and services or demand and supply is very important. But also, we're intermediating things which have an enormous societal function. And in fact, it's those things, information. Flows, whether it's the Hong Kong protests or the Halle shooting, or it's an endless amount of examples that don't necessarily have a primary. They shouldn't be analyzed exclusively through the lens of economic efficiency of this matching. But they kind of carry a societal function. That makes the challenge even harder. But this was a point which was raised yesterday in the Parliament, which I really think is absolutely right. This is not a pure economic intervention. This is also a societal intervention, and therefore it is intimately linked to public goods that we seek to protect, and that's also actually in the reading of Ursula von der Leyen. The safety rules online. That's how it should be. Now, just to answer the question that you asked, about filters and general monitoring. I mean, I think Thierry Breton was very clear. That the general prohibition of monitoring should be maintained. Against that, though, I mean, it was also mentioned yesterday in the Parliament by Timo Wölken in his intervention. There is something that we need to grapple with. I mean, I think that filters do exist. They are being used. They are being used at the moment voluntarily. But in large intermediaries that are intermediating an enormous amount of information, they decide what somebody gets to see or what they don't get to see. And I think the debate that we need to have, and it's a good start, is that what is the right division between public and private responsibilities in deciding these information flows? And that shouldn't necessarily be boiled down to kind of Article 15 discussion, which can become very technical and very legal. But that discussion is that who decides who gets to see what, and under what constraints, and under what kind of checks and balances. And I think that's a really important kind of societal discussion that we need to have. So of course, the Commission has been working on a voluntary basis with many companies, also in the Internet Forum on terrorism and code of conduct on hate speech and so on. But I think it's still an unresolved question in if there are filters being used. Maybe the Halle shooting is a great example. I think that there is a kind of, I would imagine, there is a relatively broad consensus in society that the propagation of the shooter's headcam video, shouldn't really be online, and that follows the kind of Christchurch shooting and the propaganda that was made around that. Whereas I think that that the kind of video, and some of you might have seen it, which was taken by from somebody's living room, where kind of documenting what was going on, that was important for people to have access to, So those are really fine calls, like those are really, and they have to be made very quickly and across multiple platforms, So I think in this case it worked out in the kind of public interest, But there is a question mark over this. Who is deciding this, and who's accountable for these decisions, and how are they accountable? So I don't have a good answer for this, but this is a discussion I think that is worth having.
Thank you very much. There's also some new players that you've also referred to yesterday, like TikTok. It's harder to get a grip of what kind of standards govern those players. I will collect a couple of reactions from you all based on what Pradat said, and then we'll give the floor to the public if that's okay with you. Who wants to?
I could just quickly add that one of the principles that our members gave us on our way for the discussion of the DSA is that we want to maintain a monitoring no monitoring obligation. I mean, I'm not going to shoot down the rabbit hole of the copyright directive, but we have talked a lot about, when it comes from this high-level principle to actual technical implementation, then you often find yourself talking about filters. And I think, Prabhat is fully aware, as you said just now, that there's a question about technical feasibility and about the costs associated with this that is amplified for startups at an earlier stage. They simply don't have the resources nor the time to face this huge hurdle.
Thank you, Prabhat. I think this is quite an important point that you raised, and absolutely agreed about the economics and wider social significance of the possibility to intermediate, distribute is actually essential for our society, speech, information on the function of society. I think we do have frameworks which are not just about economics. I think actually they come also from law and economics, including scholarly judges that have contributed to help us think about how as a society we want to balance different types of costs and risks when decisions have to be taken. So one example, essentially assessing socioeconomic costs and benefits of different approaches. So for example, one typical case is the case when how to balance and assess the risks of so-called type 1 errors, when there is an over-enforcement and undue takedown and undue filtering decision, which means that we are preventing some information or some speech to be distributed, or as economists we would say some demand for that information or that or speech or content or goods and supply to meet each other, because this is ultimately restricting the markets, but also restricting the ability for this important information and speech to be distributed. There is also the other case, the other type of error where there is not enough intervention. So how to balance all of these is ultimately also a cost and benefit question, though a very difficult one. And I think looking at evidence, looking at ways to frame the various points in balance are quite important. So I wonder what you think about this.
Unless you wanted to react, I think it's time for questions. I hope you're all ready. I see there is one question here. Let's get another one and a third one here. All right, start. I have a microphone.
Good morning. Thank you, Aline, for organizing this. Is it working?
Try again.
More or less. On board today.
Shout. Yeah.
Yes.
Yeah. Try again.
Can you hear me?
No.
I speak loud?
I tried it. It was working.
You can take that one there.
You can speak loud then.
I'll speak loud, yeah. Thanks. So, my name is Guido Lobrano. I work with ITI. We are the Global Association of the Technology Industry. Thank you. We are clearly very interested in this discussion, and I think one of the things that is always clear in these debates is the huge variety of operators that will be impacted by these new rules and these reforms. So there's very large platforms. There's other types of operators. The business models are also different, and that begs the question. First of all, how should we go about thinking of a framework that will affect such a large variety of operators? Also, the impact of the way these new rules might be applied in the future is going to be huge, or it might be very small depending on the operator. So the question is, how do we analyze that? Is it realistic to come up with a framework that is actually working properly for everyone? And, we heard about TV startup. There's going to be companies like Facebook. What is the thinking in the Commission, but also how do we think about the economic impact of these new rules and the social impact of these new rules across these enormous variety of companies?
Second question.
Jens Jeppesen with the Center for Democracy and Technology. We come at this from the free expression perspective. We would like to see this reform, protect and promote the internet as an open space for exchange of information and so on and so forth. And indeed, as you mentioned, Prabhat, the controversies that drive the discussion are all around speech. They're all around social media content, primarily. They're not about booking sites or reviews and other things, right? So one question is how do you frame rules that target this type of controversy and deal with this type of societal concern without impacting all of those other types of services that are perhaps not that relevant in this? And then the other question is jurisdiction and cross-border impact. So the court said in the Austrian case that nothing in the directive prevents a court or an authority from demanding restriction of speech outside of that court's territory. Perhaps maybe it would be a good thing for this new framework to make clear that a court should not do that. That's a suggestion, not a question.
Thank you. Torben.
All right, I'll just speak very loudly. I'm Torben David with Bitkom, the German Digital Industry Association. We talked a lot about liability in this discussion now, but at a recent event, and I know, Prabhat, you said you don't know everything your colleagues are up to, but at a recent event with the German Chamber of Commerce, Werner Steng referred to a third pillar for your considerations on advertising and transparency. And I was wondering if there's any thoughts, maybe from all of you, how far that needs to be addressed in this law, and how far, well, it will be, or might be.
Thank you. So, any questions? Who wants to kick off?
It's indicative. Sorry, I'm sorry. Just first, thanks for these questions. I think first a question on how do you make rules that cover such a wide variety of different services? How do you make sure that we assess the impact on the whole ecosystem properly? I think that we are conscious of this challenge, and that's also why we are taking as much time as possible, and that's also why we're talking early and openly to everyone, within the limit of our kind of bandwidth of being able to talk. I just want to stress how unusual it is for services to be so open so early in the process. At least in my experience in the Commission, I think the Commission is not even in place. And Werner and myself are going around the world giving talks about something that hasn't actually officially been decided yet. So and that also comes with a kind of listening mode. So we're taking a lot of information back. So that's one thing. And we will have we're committed to having a very thorough impact assessment. I think I also want to reassure you that our team is, has, I think, a good track record in impact assessments and taking this process not just as a kind of bureaucratic hurdle that we need to overcome, but to really actually take the process seriously. Werner himself was for almost a decade in charge of impact assessments in DG Markt. I guess you probably won't know it, but I was in charge of impact assessments for a while in DG Connect. We have some of the best better regulation people in the Commission in my team. So this is not just a kind of a kind of thing we'll do on the side. So we'll take it seriously, and there'll be a thorough public consultation, which we're also going to take seriously, and we have leaving ourselves. Hopefully, the incoming commissioners will agree with us that we're leaving ourselves a lot of time between the consultation and the actual proposal, so that it can be digested. Unlike some other cases where the political imperatives force us to go much faster. So that's just on a commitment to try and make the process as open and as thorough and so. Just maybe also to just bear in mind, Commission's impact assessment process, of course, is criticized quite a lot, and by many of you criticize it as well. But honestly, there are not many countries that carry out impact assessments like we do. So the standard. I still recall seeing the first draft of the German NetzDG, paragraph 5 was, what alternatives exist to this law, and it said none. That was the impact assessment, and that was it, one word, no alternatives, and so, I think we do a lot better, and I think we'll have. As during the impact assessment process and afterwards, I'm sure there'll be elements that you will like and other elements that you won't like, you don't agree with, but give us credit for the process, So that's one thing. Now, the other thing, again to the point, how do you deal with such a big horizontal instrument? I just want to make 2 additional points. In the Juncker Commission, the approach was really politically driven. Say, let's not tackle the big issue in the framework. Let's deal with individual problems. And I think that, so we were part of that. I wrote the communication in 2016 on the platform economy, that we laid out our kind of problem-specific approach. I think that there's a broad sense also. I think in the broader audience, I guess, is that this sector-specific or problem-specific approach has reached a certain limit, right? In the sense that it leads to kind of content by content fragmentation, service by service fragmentation, and member state to member state fragmentation. So there's now a certain kind of decoherence in the process, which is important. And the second point that I just wanted to add on to how to deal with such a complex thing is that the status quo is also a choice. Leaving it as it is also a political choice, and that will put us on a particular trajectory or not intervening. Which is also not necessarily good neither for businesses nor for society. So I think the reason why we actually are all getting starting on this project is by saying, well, if we take a hands-off approach to this and say, oh well, it's too complicated, it's too controversial, it's too messy, let's forget it. And I frankly also have some other projects in my professional life afterwards, so I don't want to negotiate for the next 2 decades, something. So we do think that there's a path, that is consensual, that needs to be kind of illuminated now. But there is a progressive middle ground. We also see that there is an opportunity to make life easier for Thierry, the entrepreneur, and we also, to clarify some of the societal concerns that are still kicking around, which are leading member states to regulate at national level. So that's just to the point of how do we do it. So the process, the risk of not acting, and the opportunities I think are there. And on the opportunity side, I also think for Europe it's a good moment. It's an opportunity to actually have a framework which works. And which could also have global impact. And this is a moment where services in China are on the rise. Discussion in the US are going on, but going on in all sorts of directions there as well. So it is also geopolitically an interesting moment for the Union to lay down what is a rights-friendly framework and an innovation-friendly framework as well. To Jens. On the Facebook ruling, whether we should correct this, of course, there is always in lawmaking a point where you think that courts are stretching the rules or interpreting the rules, in light of today's services, so far away from what the legislator had in mind, that the legislator should intervene to clarify. I think the Facebook ruling is an example of that. We can only speculate about what went on in the judges' minds. I don't have any more information than you. But what we do find, I think, from my team, and as some of you know, we have a couple of computer scientists on the team as well. I myself, have a background in industry and computer science as well. Is that you get the sense that actually it was difficult for the legal system to actually understand the connection between the ability of technology to do certain things and the rights framework that was available. This is not the only judgment. I mean, the Uber judgment has echoes of this as well, and there are a whole host of other judgments. There's some coming through, where you think that actually, the court's probably struggling with understanding how does this service that I'm seeing in front of me and the technology that I may or may not impose, function against the right. So this is a good way. On the jurisdictional issues, I think that we'll have to come back to that, and see whether it makes sense to delineate. We certainly would be uncomfortable reciprocally if the Chinese government decides that nobody can see the Hong Kong protest videos. We would be concerned. We have taken note of the mention in the ruling that it needs to be consistent with international law. We understand that to mean particularly the ICCPR, and the protections that are afforded there. So there is some backstop available in the court ruling as well. It's not a kind of free for all, but a clarification needs to be done. Extraterritorial jurisdiction, the European Union is always kind of often accused about having laws that apply outside of its territory, but I think that we need to have a fair discussion about this. DMCA rulings also apply globally, so it's
I wasn't making that point.
Well, I'm just kind of musing on, so that's if there's a copyright infringement in the US, that also has global effect. But that's copyright. Maybe that's the same. Now, Tom, on your question about advertising transparency, I think where are we coming from? I think that there are some provisions in the eCommerce Directive on commercial communications. Where I started on is that our first thing is to look at the eCommerce Directive and say, well, what did they try to achieve? And actually, Article 6 is a kind of advertising transparency rule. Identify the person who has placed the ad. And so in a kind of way that the history kind of keeps repeating itself. A lot of the questions we are asking around on an advertising right now, to identify the author who has bought these things. They're already on the statute books. Have they been enforced? No. Are they working in light of today's services? Probably not. Was the original thought a good idea? Yes. Do they require a fresh look? Yes. So that's a little bit where we're coming from. On an advertising as a service is also not explicitly mentioned anyway, except for these kind of commercial communications. So but we all know, that this is a really important service today that merits some looking. This, by the way, also something we're looking in. The observatory that follows the platform to business, because there we already looked at advertising at the time, decided that we didn't want to put it in scope at the time. We focused on ranking transparency. So it is something that we're looking at. E-privacy is going on still. There'll be some, but it's also in the news. So I don't want to speak too long about it, but it is something where we don't have a kind of clear orientation, but it is certainly one of the issues where we're looking at the moment, in terms of kind of service provisions. It's also an area, by the way, there's some fragmentation because there are some laws on advertising transparency in Hungary. There's some laws in France. There's a proposal in the Irish Parliament on advertising transparency. It's not just a matter of looking at the sector, but this is also an area where there's some fragmentation.
Can I just quickly add to that, because I think both Guido's and Jens's questions were on the unintended consequences of this potential DSA, and I think for us at this stage it's going to be very important, of course, when we come from this high-level discussion, to have a evidence-based debate, so a strong consultation process. And one of the things our members have told us is, please, if possible, focus on the problem specifically, or if there's a problem maker, focus specifically on that. And if you cannot target that, for instance, because many platforms host third-party content, indeed, then you have to be particularly careful to not hit my friend Thierry. And it would be ironic or unfortunate if a legislation with a view of targeting big players, or made with a view of targeting big players, ends up hitting smaller startups more. That's the first remark. And just on your point of sectoral laws potentially having been exhausted, I would just add that one of the maxims our members have given us on our way is that horizontal laws should be put in place if they can clarify, and if again they don't end up adding another layer on top for the European entrepreneur. Cheers.
Many thanks. No more reactions? Then 1, 2, 3. Oh, sorry, yes, 4. Okay. We'll manage.
Just a quick question from me. Speaking of impact assessments and evidence-based, is the current work within the Observatory for Online Platforms going to feed the impact assessment for DSA?
Second question.
Hi, my name is Nadia. I work for Avas. And my question, we have been talking about illegal content. I would like you to talk a bit more about false content, so false information in the platforms, if the DSA intends on approaching this issue, how, if there is already some kind of shape around this, and also from Anya from Facebook, if it's possible to say something about that. Thank you.
I'm Ali, I'm a private consultant. Well, you kind of touched on this a little bit about some of the things that are happening on a global scale. And I was just wondering, is looking at other jurisdictions, other regulators, is there anything that you look at and see that other people are doing that go, that might actually be interesting, and maybe we can do that here?
My name is Kervin. My background is more in software than in policy. And when we're talking about services, I guess everyone is realizing that more and more there is just a few companies that are providing a lot of services people use online. And that's often due to the network effects and the lock-ins that these platforms create. Everyone has to be at the same platform to communicate with each other. In the note that was accidentally published in June, there was also a mention of service interoperability and the possibility to extend data portability to also require services to be interoperable so that you can switch from one provider to the other without losing their connections, just like you can do with email, but not with Facebook, for example. Is there anything still left in the plans about it?
Thank you very much. Many good questions. Thanks, Colin.
Yeah, no. So just one background. I think that just one step back. I think it helps us to answer several of these questions. Is that I think, Benedict, you're absolutely right, and we need to take a problem-driven approach. But just as I was kind of waving the flag of the better regulation process, it actually is a relatively logical structure that is imposed on us. Like and that forces us to first kind of go through this evaluation step that I kind of outlined earlier on, and then decide what is the kind of delta, if you like, what's the gap, like that actually requires us to intervene at all. It's a fairly high standard. We must make sure that there is actually a real problem that we solve, that we add value, that it's still coherent with existing rules and so on. So we are holding ourselves to a relatively high standard to not invent problems that don't exist. I think that so, and you will scrutinize us on whether we get that right or not, and I think this will be part of our conversations as we are progressing. I think we continue to have the ambition to be as open as possible around this aspect. Just when we speak about problem-driven approach, let's just also not forget. Sometimes we forget opportunities as well. You know, like solving, you know, like if you go very deep down the problem-driven approach, you know, say what's the problem you're trying to solve? This is what we will answer, and we're working on. You know, sometimes you miss though. You know, what's the opportunity here? You know, because the problem is that I have something, a friction point that I want to go away. You know, but there's also cost of inaction. You know, that we don't talk about. You know, like the opportunity cost for something. So let's also talk about that as we go forward. And I think that something that I said at the moment, the fragmentation of the single market, the evolution, the inaction, you know, actually has a very, very high opportunity cost at the moment. You know, like we are all for being very sharp and very clear on the problem definition, but this is just a background. Now, Karina, you asked the question whether the observatory will feed into the impact assessment. Yes, but once we are clearer on what the problems are that we will tackle in which instrument, and this is also something that I alluded to earlier, that for the platform to business we will continue to look. So at one point we will segment problems into packages. It's too early for this. And at the moment we are. The e-commerce directive revision is focusing on internal market and content-related issues. You know, so those parts of the problem definition that fit in there, they will feed in. You know, there's some work of the observatory which is relevant, but mainly it has been dealing more with the kind of interactive fairness and competition and fair trading. So you know, so at the moment it's a little bit of a parallel stream, but there are some interesting touch points. You know. So it will be. Now, a question from Avaz about whether we will talk about false information. I think, well, in our impact assessment, for sure, we will look at it in the sense that this is a new problem that wasn't on the table in 2000 when the e-commerce directive was drawn up. You know, so you know, that's really a kind of a classical question. You know, like when we do the evaluation and when we do the problem analysis, this was clearly a problem. That wasn't anticipated, for which the framework wasn't designed. You know, that's new. It's relatively well documented. I think what is too early to say is whether then the solution lies in this instrument or somewhere else. You know, like but to analyze that there are new services, I think that new services are spreading information, misinformation in this way, that there is a new challenge in freedom of expression, that this is not illegal material, which was what the e-commerce directive was designed for, and therefore it has a different standard of protection under the charter. You know, that these are new problems that need to be analyzed. You know, and I think that the work that we're doing on the code of practice, there's a link to the you know, kind of online advertising regulation proposals that have been made in various jurisdictions. You know, this will feed into this analysis, but I think it's too early to say that this is where it will be regulated. You know, there, you know, like I can go into more details, but are we learning from other legislators? Yes, for sure. I think this is one of I mean, at the moment, we are in structural conversations with almost every major jurisdiction in the world, either because we have structured dialogues with them, we have a formal or informal cooperation, you know, with all, when we have, of course, our DG Connect has a team in many countries around the world, so we do have dialogue. I have to say, at the moment, the information flow is a little bit the other way around. Other jurisdictions are asking us how you're dealing with that, particularly around GDPR and so on. You know, just yesterday I got an email from Japan. You know, they are kind of almost copying the platform to business regulation. You know, so there's a lot of information like this. We are always looking at that. You should know, though, and it's also important, is that in free trade agreements, including in the WTO, intermediary liability provisions are usually part of the negotiation. So we have a kind of structured dialogue on whether what people are thinking around this. Also in the current e-commerce negotiations on the WTO, we are taking, of course, a cautious observing line in those, but we're following them very closely. You know, so that's just how much we you know. If you have a particular legislature in mind that you think they have a great system, then let us know. I mean, just final on this international thing. After the Christchurch incident, and there was also more intense collaboration between industries, but also with other jurisdictions. Australia and New Zealand particularly, they got very active in this and said, how can we solve this problem? And they started a kind of, under the umbrella of the Global Internet Forum for Countering Terrorism, there was a kind of structured cooperation. Canada is supporting it financially and so on. So there is a kind of a network of people. Interoperability of software. Yeah, I mean, so I'm not at this particular point. I don't necessarily see this as part of the e-commerce directive revision. You know, this is an issue which is much more, as you say, related to kind of making sure that there's that switching costs are low, that markets are contestable, that there's kind of no necessarily that we limit the speed at which walled gardens appear and kind of are grown. You know, so that's something that's something that is. But I don't necessarily see this as a core issue in the e-commerce directive revision. I think that it should be in the considerations about market power and you know, contestable markets and switching costs and so on. That certainly we will look at it. Just to come back, I think one of the challenges, I mean, we've seen the private sector initiatives on data portability and data switching and so on. We're still analyzing those proposals, whether they really help anyone or whether there's a real demand for such a thing. Like, you know, so be interested to hear also from those stakeholders what the actual experience is. Just for the record, I mean, I think that the messenger interoperability question, you know, that's something that has already been addressed in the electronic communications code, you know, so at least partially, and there's a kind of there's a window there for looking at it. When we speak about data sharing and data access and interoperability, I think what is very important for us to be clear, this is more speaking from my perspective, is to say which data set, who wants this data set, for what purpose, you know, that's on data sharing. Interoperability is a little bit similar, you know, which service should be interoperable with one. And yesterday there was an explanation about the Mastodon service as one example, you know, okay, but that's one of many kind of interoperability. We've seen the W3C standard for social media interoperability from a couple of years ago, which we are kind of revisiting at the moment, just out of curiosity and to find out what exactly what happened to that, you know. So we are kind of curious about it. I don't see it at this particular point as a core issue of the revision of the e-commerce directive, more in terms of an issue that should be addressed in order to make sure that markets are switchable and that are contestable. You know, like more in the follow-up to the platform to business regulation as an issue. But it is something that also requires a fair amount of research on our side, you know, to an understanding the various nuances and the ups and the downs of such a thing.
Oh yes, sure.
So a couple of questions. I think there's a lot of interesting insight here. First one on Japan, for example. So are we able to charge them a fee if they're copying our B2B regulation? Because next time they may be able to do it even more advanced, and then we have to, as Europe, catch up. So we have to be careful. On one question I wanted to put to all of you is on, especially when we have horizontal tools and tools that can affect a broader categories of business. I think this was also the first question from the floor. How can we map and trying to track potential unintended consequences? We've seen in other forms of regulations and interventions where issues get scaled up on for instance, cookies. In the interest of privacy, then what was then called cookie fatigue. So the repetition, the extent to which frictions and costs get amplified across operators, and then it can become a burden. I think this was acknowledged in later impact assessment, how to predict this in the first place. Also, when thinking about wider categories of business that are affected, I think there were conversations on taxation, which started with a focus on the sector. Now these conversations are on a wider level. I think there's a broader set of businesses that in the next 2 days at the OECD in Paris will scratch their heads and ask, is this about all of ourselves? Is this all about all large businesses on the planet? What does it mean? So what are the ways to in a sense look where the devil in the detail may be, and how to think how does this scale up when rules change, and what's a good way to test and see how big costs can become, or frictions, or impacts. What's a good practical way in your experience? I put the question to all panelists.
On the question on disinformation, maybe starting from there, I today was focusing quite a lot on illegal type of content and how we approach that. We of course have a whole set of policies in place, how we deal with what we call harmful content, so disinformation falls in that bucket, also because disinformation per se as content is not illegal, yet of course it's unwelcome on the platform. It really kills the authenticity of the discussion, and we of course try to put certain tools out there, which of course we might have talked previously, and broadly speaking are described in our assessment of how we did the code of practice in disinformation with the European Commission and other companies, which is right now, I think, as far as I understand, being assessed by other auditor and also ERGA, which is the body of European regulators, and based on that the Commission will probably think of next steps, and that also relates to issue of specifically of political advertising, how that will be addressed in the discussions next year. So we of course also don't know how that will go, but yeah, definitely not something that we disregard. It's just we treat it quite differently. First of all, we don't remove it because of course there is certain issue that we can't control and be arbiter of truth of what people see on our platform. Yet of course we have policies to remove fake accounts, we have policies to remove all the so-called farms, trolls, whichever way we want to call it, because we think that if someone is not using his authentic identification, that really kills the discussion first and foremost. And of course, if someone wants to promote the message that the earth is flat, that's not per se illegal, it's not per se like hate speech or any kind of abuse. So there is just different set of rules. I really like the question about inspiration from other jurisdictions, by the way, because I think this is a plea to European Commission that this is not only the rules are being set for us here in Europe, but of course European Commission is and European Union more broadly is a very important legislator in the global scale and in the global scene, and there's a lot of inspiration that's being taken. I can, for example, give an example that we already mentioned here. Copyright Directive is also something that I think some jurisdictions are looking into, and that's not necessarily always good idea, because of course there's certain principles that we have here in Europe which not always exist in every other jurisdiction. So just copy and pasting something, it's not always a great idea. So when you have those discussions, it's always great to have that additional background. Yeah, I think I'll stop here.
Just quickly, since Harman mentioned the leaked, I don't know if it's still called, so-called leaked concept note. Something we really liked in there was talk about sandboxes. Just it's very early days still, so we'll see how this looks like when we look at an actual text. But the idea that innovation is in principle faster than regulation, and startups are doing something new in a new way is a great place to kick off with the discussion on sandboxes, and that's something we're really looking forward to discussing with you.
Thank you very much. Any more questions that I can take? One here, okay.
Thanks. Very good morning. Rob Murray, I work at NATO. So firstly, I'd just like to understand where DSA fits within the broader data sovereignty discussion, first of all. And secondly, from each of the panelists, we can get in one sentence what you believe could be the major benefit and cost of DSA, from what you know.
Thank you.
Hi, Jamie Patel, LVMH. I was glad to hear Prabhat finally say that this is not just about economic rationale and motivation, but also has a big societal impact. And I think that shouldn't be forgotten in this area. Because sometimes I hear people talk about how the problem is too big, that there's too much content being run through these platforms, and therefore it's very difficult for them to do anything. It reminds me a little bit of how we talked about banks before the financial crisis and how they were too big to fail, and we saw how that turned out. And it's very odd for me to hear this kind of approach being taken, whereas in almost every other part of European policymaking, this is not the approach that's taken. In consumer protection, environmental protection, regulation of medicine, we don't say, oh, we still need to get startups into these places. We talk about how do we protect European consumers and citizens. How, and so isn't the problem actually being looked at the wrong way around? They're saying there's so much content being run through these platforms, so we can't do anything. It's actually, how do we make that amount of content packaged up into regulable chunks, rather than saying it's just too big for us to deal with?
Thank you, very good questions. I think we can take them from there. We have 5 more minutes.
So yeah, another great. I think there was a question from NATO for everybody. So I don't want to use all the time now. But so on the unintended consequences, Bruno, what you said, how can we make sure that we don't? So I mean, first of all, there's nothing in life and nothing in regulation that is kind of zero risk. I mean, so there will be some unintended consequences. Simply because also, I mean, I think we should step away from the illusion that no matter how good our processes are, but this is an inherent risk, and I think that kind of just in the same way that we allow risks in other parts of society, there's also a risk here, So I mean, I would be dishonest to you to say that there will be no unintended consequence. I mean, I just simply I don't know. Nobody has the power to make such a statement into the future. What we can do is we can commit to a process that tries to minimize those unintended consequences to the reasonable way. And consequence scanning, careful impact assessments, a lot of stakeholder dialogues, that they're kind of the ingredients of such a thing, But that there will be nothing in the new rules that will have unintended consequences. I mean, let's not hold ourselves to a standard like this. I think then we can just do something else. And so. And actually, the flip side of that is exactly what Benedict said. Sandboxes. We actually want a risk environment. We want an environment where we can take controlled experiments. We can run, we can do stuff that isn't necessarily completely inconsistent with the rules because the rules were written for something other kind of services in mind. Now I have a service that doesn't fit anywhere. How does that work? I mean, we've been thinking about sandboxes quite a lot. I think that this requires a separate conversation. I think than this. But I'm hearing we're watching with great interest also French initiatives on experimentation around facial recognition. Which are very interesting approaches. To try out something in an area. Sandbox has been talked a lot in the financial services sector. I'm not sure whether that really translates so well to kind of digital services. But let's have a conversation about how to facilitate experimentation more. And we can. But that's kind of the flip side of the unintended consequences. So we can't have both. We can't have an environment that allows innovators to break the rules because they were not the right ones, and at the same time have no unintended consequences. You see that they're kind of both. They're kind of opposite sides of the same coin. So we'll have to have enough flexibility in the framework to allow. Some gray zones, some cooperation with regulators. Some constructive dialogue structure. This is something that. How does it fit into data sovereignty discussion? Well, I think that the data sovereignty discussions are right at the beginning at the moment. I don't. I think that there's a conversation that we're saying. Well, we want to have our own assets. We want to have our own value chains. We won't want to rely on third countries so much in many of the critical value chains that are going on. I think these discussions are still in the process of being crystallized, and they are much more geopolitical than the DSA in a way. Because they are asking, are we comfortable with a value chain that we don't control? In many critical parts, this has to do also with semiconductor manufacturing, it has to do with high-performance computing, cloud infrastructures, and all sorts of other things. So this is not just about the Digital Services Act. I think that there is a touch point, is that by setting our own rules, by being the rule setters, hopefully in a way that kind of reflects the way we want to structure our informational space, that's an important component of sovereignty because it's an assertion of our rules, Actually, so that's sovereignty means that you have the ability to assert the rules and set them the way that you're not a rule taker, you're a rule setter. So that is a link to the one the one line about benefit and cost of the DSA. The cost is clearly some adjustment to the status quo. I don't think it will be business as usual and it will be completely smooth transition into there will be a cost to the status quo. And companies will have to adjust their processes, their internal processes, whether it comes to flagging, to responding to notices, to cooperating with a regulator, with being accountable in a more structured, formalistic way. That's a cost. The benefit is actually a much more harmonized set of rules, and a clearer, updated, set of rules that gives greater safety and protection and empowerment to users as well. So that's the cost-benefit ask. Now, on the question for LVMH on the societal impact, I think that you are right. I think it's not only about startups in the single market; it's about everything. But it's such a multifaceted thing that we can't really trade off one against the other. We will have our challenge is going to be to do all of them. To find the right balance that is pro-innovation, because this is still a space where there's a lot of innovation going on. And we want to have that, but to have a high level of protection of users. This is why safety sentences in the rules. I think I'm actually rather optimistic, to be honest. I think that it can be done. I think it requires more conversations like this. But I'm rather optimistic.
Quick reactions, and then we'll have to wrap up.
Perfect. Maybe just to be 100% clear about sandboxes, that they're not, to us they're not a place to break the rules in that way. They're kind of a way to experiment, right? To try new business models while being compliant, just to be sure that startups aren't perceived as rule breakers. I just wanted to answer quickly to the gentleman from NATO about the data sovereignty question. Because I think, I agree with Prabhat that we're at the beginning of a conversation, and I think if there's 100 people in this room, there's probably 110 definitions of what data sovereignty means. We've just been also kind of trying to dissect a bit in the various discussions on content or on AI or on cloud, what this means. Again, for us, if this means resorting to protectionism or data localization, then I think this would be problematic for startups. But if this is about empowering startups and ensuring a more competitive landscape, then we're totally there. And in terms of costs, benefits, I think I already mentioned how to empower European entrepreneurs enough. And I think the biggest, looking at the conversation also today, I think the biggest risk is, I think, really, if we make this, if we bring in so many topics here that it becomes a very convoluted, messy discussion, and we've already seen the discussions on hate speech, false speech, illegal speech. I heard mention of elections in reference to the DSA or collaborative economy. There is so much thrown into this debate. I think all of us have a big job ahead of us to making sure we can clearly look at this and not just focus on the problems and also at the opportunities for sure, but to not make this Christmas tree legislation.
Thank you for the lovely metaphor. If someone wants to say something within 1 minute, that would be all right, no?
I can just quickly. From our perspective, the DSA opportunity is to indeed, what we were thinking today, is to create rules for platforms to basically promote this responsible behavior, and this is a big opportunity. And of course, the risk is on the other side, is that we depart from this discussion, start discussing all different issues, and try to insert in this all, let's say, issues that we wanted to address for other types of regulation, and that will probably not be a successful discussion, and will take you probably 2 decades to finalize.
On the question of main benefit and cost, I agree. The main benefit of this type of initiative is to complete the job of the single market that was set up there already in 2000. Maybe important to distinguish between the value of completing the existing principles versus new principles, because if we have some fragmentation, then first of all, let's look at the job to be finished, to be done, and then consider new principles and approaches. And then in terms of costs, we know that the in sharing information and content and all the things that we share via the digital tools, we have efficiencies due to the networks effects, the scale, the scalability, and also that we have different players with different information at stake about what constitutes problematic content. So a major cost can be if we end up with rules that place responsibility on those that do not have the right information, or disempowers actors from that have the information and can help flag up and explain where are the rights, where are the problems to intervene in an efficient way. So I think the tools are giving us lots of opportunities, but it's important to think about the balance, because that's where the costs can come.
Clearly, we need to have more conversations like these, and I'm sure we will next year. Thank you so much, everybody, for coming. You will receive a recap in the video in case you missed a few things. I'd like to give a big round of applause for our panelists and to Thierry as well.